Good morning, everyone. The house issue has been settled. Now we have power, and now we can start. I'm called Awori Christine, the acting CEO of Uganda Law Society. I take this opportunity to say Happy New Year to all of you. We give thanks to God that we are still alive. We don't take it for granted. So many went with 2024. So we are excited that God has given us life, and we are here in 2025. I welcome you all to the Uganda Law Society. Uganda Law Society is the Uganda Bailiffs Association for all the lawyers in Uganda. It has been in existence since 1956. That means it has been here around for 69 years, if my mathematics is correct. Now, Uganda Law Society has mandates to support the government, to support the public, and we have the Uganda Law Society Act that guides the business of Uganda Law Society. We also have the Uganda Law Society Strategic Plan, which we revise every 5 years to guide our implementation and day-to-day work. I welcome all the members online. I welcome the members present here. I welcome the council members present, the treasurer, the vice president, and the president. And I also welcome our special guest, the Lord Mayor, Mr. Elias Lukwago. You are all welcome. We are meeting today, like I say, that Uganda Law Society has a mandate to the public and to the government. We read news every day, we listen to news, and we know what is trending in the country. Among the mandates Uganda Law Society has is to ensure that there's rule of law in this country and there's access to justice. And the council members you see here support us on the governing side, but also have management that runs the day-to-day work. I also welcome and recognize our media, who are very vital in the work we do. The whole public gets to know what we do through media. So I recognize you and I welcome you as well. So today we are meeting purposely, I'll call it to launch our weekly new radical issues. We have issues happening in this country. Since the new NUBA came in place, they have been handling these issues. We have been appearing on the press about what is happening and our positions. But today we are launching officially that we are going to have every week issues touching this country, trending in this country, and they touch the issues of rule of law, access to justice, justice itself, because we must ensure, as part of the justice system, that justice is for all. So we are partnering in that. So today we have 3 main issues we are going to touch. We have a petition by the taking us through the position of Uganda Law Society about that petition. We shall have the Vice President of Uganda Law Society giving the position of Uganda Law Society on the recent case management census. Then we shall have the President of Uganda Law Society giving a position of Uganda Law Society on the General Court Martial. Then we shall have the Lord Mayor giving a position and a petition.
I think it would be the other way around. The Lord Mayor will present his petition.
Okay.
And our response.
Okay.
Also, Baguma is going to speak first.
Okay.
So when we're done, we invite Baguma for Bailiffs to speak his petition.
All right. The Lord Mayor will present the petition on the legal matters that have been happening, especially to Dr. Kiza Wesije. And another, we all know what has been happening in the court martial. So he will present a petition, and the President of Uganda Law Society will give the position of Uganda Law Society. Before Mr. Treasurer comes to give the position of Uganda Law Society, the leader of the association, Mr. Baguma Patrick Robert, will come and make a presentation. And like we outlined it in our banner, we shall start with Mr. Baguma Patrick. I welcome you to come here and take the podium. How many minutes do you have?
15, 20.
Yeah, it's okay.
Good morning, everybody. I'm by the names of Baguma Patrick Robert, the General Secretary, Uganda Court Bailiffs Association. Warm greetings from my president, who is not around today. He is having a conference in Morocco on the African Union for Bailiffs. The headquarters are in Morocco, and right now he's there. Before I commence, I will call upon my colleagues I came with to come and stand with me to give it a broader face. At least some committee members, like 4, may you proceed and come and stand with me as we present. Thank you very much. Rwamkaga, Mukanga, Kuranima, Asafu, come. As a General Secretary of UCBA, I'm the custodian of all the documents and all the seals in the association. Thank you very much, Acting CEO. We as UCBA, we don't have a CEO. Our CEO is the President. And in that capacity, as a General Secretary, now I'm the CEO. Last week, we approached the President of the Law Society. We had pertinent issues. The pertinent issues affecting the UCBA is our rules. The new rules they imposed on us without consulting us are affecting the association and the bailiffs at large. We petitioned the Chief Justice. It was around the 22nd day of July 2024. But it seems that they are dodging us. I don't know. That's why we sought support from the Law Society. Judiciary is trying to impose the rules on us and they are dodging us. They don't want to give us audience. They don't want to listen to us. All the petitions are not being replied. And secondly, we petitioned the Constitutional Court on the matters affecting the UCBA but are unconstitutional. You know very well that the Constitutional Court is judiciary. And it is as if we are petitioning against judiciary. And you are expecting an answer from judiciary. It is as if they are going to rule against themselves. What they have decided is to dodge us. The petition is there. No one is fixing it. We have filed an injunction. The injunction is redundant. No one is fixing it. Now we are left as if we are orphans. In that position, we request the President Law Society to come and support us in this fight because we are alone, we are orphans. Basically, our challenge is on Rule 28.3. Rule 28.3 is on the requirements for bailiffs to have a license. As the laws of Uganda are clearly stipulated in the Constitution, they cannot act traverse. Now, at first, on the Chief Justice was launching these rules. Mr. Vice President, you are welcome. You can join me here. Those rules, when they were launched, after having been made by the Rules Committee, where the President of the Uganda Law Society is a member, this Rule 28.3 was not there. It wasn't there, but they proceeded and gazetted another rules which included it. So I don't know that inconsistency, where it is. And that rule, basically, we are referring to, I can read it verbatim. It says, Rule 28.3 is to the effect that court bailiff licensed under the revoked rules who does not have a diploma in law shall, notwithstanding Rule 81B, be eligible for the renewal of his or her license for the period not exceeding 2 years to enable him or her to acquire a diploma in law. Now, those 2 years they are referring to were during the lockdown, during the COVID pandemic. All the schools were closed down. The transport system was down. The chairman, Rules Committee, was also at home, including the President Law Society was also at home, was not going anywhere. Where were they expecting the bailiffs to have those diplomas in those 2 years? To have it implemented this year. Now, my humble appeal to the President as the member of the committee, the Rules Committee, I petitioned the Chief Justice. I gave a copy to the President of the Republic. I gave to the Minister of Constitutional Affairs, the Attorney General, the Principal Judge, the Deputy Chief Justice, the President Law Society. I gave it to the Judiciary Secretary. All have copies, but they were all ignored, including you, Mr. President. I don't know what happened, but the President had a copy, the President Law Society. Would we think that all of us, but of them now, we further requested the the Deputy Chief Justice, who is the head of the Constitutional Court, on the petition number 1 of 2023, Uganda Court Bailiffs Association versus Attorney General, who requested to expound it more, to explain to the Chief Justice on the agency, on that matter, but there's nothing coming out from there. We thank the President who has given us audience today to come and explain our challenges, and at least think that they will at least fight with us. And you see, we are going to be affected. This list, Mr. President, I had not yet given it to you. When they told us to go back to school, you are seeing on the list, the continuing students with LLB right now, they are 125. No, it is the 122. Those that are doing LLB right now. They are going to be affected when they have been scrapped off. Because the rule says that if you don't have a diploma or a requirement to have a license renewed by 2025 January, you will not be licensed as a bailiff. Now those 122, they derive their likelihood. They get that tuition from this business. They are going to drop out of school. We have 125. Those are on diploma programs in various universities. Now, Mr. President, sir, will you also allow those members of Uganda Court Bailiffs to be on the streets without work? Mr. President, sir, I request and humbly request that at least you as a member of the Rules Committee, at least take our voice to the Chairman Rules Committee, who is the Chief Justice of Uganda, to have our voice heard. And we renew, at least they can give us more time. Mr. President, sir, we humbly request that at least you and your fellow committee members allow bailiffs to continue practicing without this requirement, at least for 2 years. You see more than 300 bailiffs at school. Others are on LLB, others on diploma, others are enrolling. To have at least 2 years more to implement, Mr. President, sir, along 3 lines we are requesting. We humbly request the Rules Committee at least to facilitate that mediation. They mediate, and we have a consent. That consensus will have us at least a leeway to renew our licenses as we go back to school, as we study. Mr. President, sir, we request at least for a deferment of Rule 28.3 implementation, as we argue judiciary to postpone the implementation of Rule 28.3 beyond the scheduled date of January 2025. That deferment would provide an adequate time for meaningful engagement, further discussions, effective transition planning, and the resolution of the ongoing legal challenges with the Constitutional Court. At least we request for an adoption of a humane transition approach. We appeal to the judiciary to adopt a humane approach to this transition, as has been done in previous reforms involving Magistrate Grade 2. Mr. President, you very well know that Magistrate Grade 2, they make rulings, they make judgments, but they don't have the requirement. They were left to be there And now they are forcing the bailiffs who just go on street to arrest other debtors. We don't need diplomas to arrest the debtor. So, we specifically propose entirely exempting the existing practitioners, the bailiffs practicing now, from this new rule. Let this rule apply to the new entrants only. Given the sensitivity of the urgency of this matter, we humbly request physical meetings with your office to discuss these issues in details and explore practice solutions, Mr. President, sir. Through your office, we request at least, if we cannot meet the Chief Justice, at least you can meet him. Whenever you are meeting the Chief Justice and you are having your breakfast when you are in the hotel, at least you hint that the bailiffs are not well. They need 2 more years.
Not 2, 5.
Whatever, even the 2 years I'm talking of is not there now. We are just begging. At least 2 more years to have our petition disposed of in the Constitutional Court, and these students who are continuing with their studies complete as human beings, Mr. President. And Mr. President, sir, I will invite at least two more, my Vice President, and this is the Vice President of East African Court Bailiffs, who is the former President UCBA. They submit, they add on. They can add on what I have said. Mr. President, thank you so much.
Granted.
I will invite you. Mr. President, Uganda Law Society, members of the place, fellow bailiffs. First of all, I'm sorry I got the notification, but I had an appointment with my doctors who delayed me to reach in time, and I'm sorry about that. Mr. President, our coming here is our last resort. We have gone to different offices, the judicial officers, including the DCJ. But, Your Excellency, we thought after going through all those offices and we were denied opportunities, we sought you as our last resort, because surely we followed the trend of your campaigns of banging the tables, and really this time around we pray that you can do both. I represent Kanyesi Jabrian, who is indisposed, but nonetheless I'm here, and I may not go through what our Secretary General has occurred here. Your Excellency, I want to really pray that the time for banging the table is now. We are over 500 members of the bailiffs, and over 300 members are being pushed away. Imagine these are senior members of the bailiffs who have been deriving livelihoods from this business of bailiffing. They have got families, they have got to educate their children, they have really trying to improve their lives and family. Imagine if you push all these people away and they go on the street. It really doesn't make sense. And as our Secretary General was clearly saying, it was surely victimizing us. Because how do you make a law without consulting the stakeholders? None of the members were consulted. How do you sit in the office and you make the law that victimizes the entire bailiffs fraternity? Your Excellency, I'm in my second year. I'm now going into the second semester doing LLB. Plus, this Secretary General is in third year, plus many others who are doing diplomas. How do we pursue our dream while on the street? This is very discriminative, because where do we get tuition anyway? We've been doing execution and we get tuition, we go and study. Your Excellency, as you well know, we previously they would support going back to school, even in government. those public servants, they say, you go back, pick a diploma, pick a degree. How do we really pursue? How do we even do these diplomas when we're on the street? Your Excellency, I really came late and I do not want to consume much of your time, but those are our core points, and I thought they ought to have seen that, you know. For those few remarks, I want to invite my comrade, Emeritus Bonero Mukaga, is our senior member and a former president, to also highlight some few remarks. I thank you so much.
For the sake of effective presentation, if you can use a different language other than English.
I'm going to try. Yeah. Okay. Uganda. Happy New Year, Mr. President, ULS, Mr. Mayor, the Executive, Uganda Law Society. I'm called Bonero Mukaga, the former president of Uganda Court Bailiffs Association and the vice president of East African Court Bailiffs. The issue of bailiffs and execution of court orders is broader than what they are reporting. The state has hijacked the execution of court orders, and it is in limbo. Today, to execute one single warrant, you have to go through 11 offices, including State House. This is unfortunate. Mr. President, today as I talk to you, the RDC of any given district has powers to reverse the judgment of court of a highly profiled judge, and he will question the English. You find an RDC who is a primary school teacher questioning the judgment of a judge. It goes without saying that the whole process is hijacked and is in limbo. That's why all these rules are coming up, because nobody is going to say a word or query them. Everybody is working from utopia. When we take, for example, the mayor Lukwago gives me a warrant to recover 20 million. The DPC will say, look here, if you don't pay me 2 million, I'm not going to help you. That money is not mine. It doesn't belong to me. It belongs to the judgment creditor. They are much, much more. And for sure, I am not surprised that even the management of judiciary doesn't want to meet the bailiffs. I have a warrant, we have warrants which are stuck in State House, awaiting the presidential go-ahead. You people who learned, you know, the CPR, I don't know under which procedure that is. But we need a radical change. We need to change these things. We are getting a lot of hiccups from RDCs, from DPCs. You can imagine that even a small LOC, one person, as long as he's from NRM, he will stop the execution. Now that we're standing, Mr. President, what we need as bailiffs, we need an act of parliament. That's where the act of parliament will solve everything in Uganda. In Rwanda, they have an act of parliament. And in Rwanda, execution of court order is very smooth. In Kenya here. These boys from South Sudan came here to benchmark and learn from us. But today they are doing it effectively. For us, we are just gamblers. We don't do anything. Most of the beliefs you see, they do it according to what they want, not according to the laws. This is because of disorganization both at the state level and our principles. I have one weakness. I always speak the truth. I'm an old man. I wouldn't care. But the truth is, basebo na banyabo fe tuli ba wanyondo ba koti twasoma degree ndala tuina na balala baina PhD na balala baina masters naye ate gwe bw'oŋŋamba ngende nsome diploma nga nyina masters mpulira amaanyi gampedde nsomayo biki? Wali olabyeko Wanyondo ayogera oluzungu ng'agoba omuntu anyaze onumugamba ki? Waliwo omuntu anyaga amanyi oluzungu? Ndikuba ekizimbe wansi njogere luzungu lwaki? I don't need. Era omuzungu yali mugezi, edda abantu babayitanga ba broker ba Wanyondo bayambalanga ebiwali ebyakaaki n'ekisupi ekinene. Bali tebamanyi luzungu. Ye bamuwanga, for us we are like dogs. We get orders. They tell me go and arrest X. I'll go and arrest X. I don't have to negotiate with you for what? I'm supposed to take you to court with all the convenient speed. That was the gist of the matter. Now, the judiciary wants us to get a diploma, yes, but they have forgotten one thing. When they recruited people previously, there were some who were senior 4. Now, if you tell a senior 4 to go and get a diploma in 2 years, I don't understand, because he will have to go to senior 5, 6. That is if he passes. Then he goes for a diploma to those already 4. They are already old, they will have retakes, he might fail all the subjects. So, honestly, a man like me, if you tell me to go in class with my 3 daughters, after class for them, they will retreat to their phones to go on WhatsApp and, TikTok. Me, I will go to look for what to eat, for them to eat. We are asking for 5 years, solid years, so that we can be able to adequately qualify. We will get the diploma they want. If people like Moses Ali got it, we can also get it. But we are requesting for time, Mr. President. Let me take this juncture to thank you, Mr. Everybody doesn't like us because of the nature of our work. For the last 2 years, our principal, our patron, the Chief Justice, and the Chief Registrar have deliberately refused to meet us. It is so unfortunate. I wish they could do it the Jesus style, but they don't. Mr. President, out of the 300 people who are in school, they are not refusing to go to school, but they are saying, we need time. Some of these magistrates, you see the bosses now, they also came upgrading. They were G2s, others were teachers. So this is not new. This is not, the biggest problem which always disturbs my mind is today you'll be on the other side of the table. You forget the other day you'll be on this side. Yes. You remember what Mr. Karusenga said? These days, he makes a lot of appointments to go and see somebody. But in the past, they used to come and see. Those people who are telling me, okay, you go, you are not going to work. One day, they will also tell him, go, you will not have to work. And by that time, maybe, I will be in Mr. Lukwago's seat, I'll be mayor. And he will come to see me. So, we are saying, let's harmonize. Let's have dialogue. Let's talk. The idea of believing court bailiffs were riffraffs, that was in the past. Yes, in the past, court bailiffs were riffraffs. Today, it's the reverse. We no longer have riffraffs. We have intellectuals who went to school. Now, my understanding is this is becoming almost a general phenomenon that in every corner of Uganda, at least 1 or 2 people are complaining about judiciary. Me, I'm not complaining. I'm only begging the Chief Registrar to listen to us. The Chief Justice to listen to us. The Chief Registrar refused. Fine. Well, at least let the Chief Justice listen to us. This is what we are begging. We are on our knees, by the way, we are begging. We don't have an alternative. We are brought to understand this country belongs to some people. We agree. But today we are begging, please listen to us. I have behind me about 6 or 10 people, plus my friends. Everybody has people behind him. So if you say you are sending away 300 people, in the nutshell, you are sending away about 3,000 people from school and other related issues. Mr. President, I know with your style of work, you are going to help us overcome this. Mr. President, I am on my knees begging you to help us overcome this. And lastly, I would like to kindly request you to find the time and come address all the bailiffs in this country. We are about 560. Please come and make changes in our minds. Please. Thank you, Mr. President.
Thank you so much, Emeritus Bone Ramukaga, Your Excellency, the President of Uganda Law Society, the Lord Mayor, my long-time friend. We have surely echoed our voice. And as I said earlier, the Bailiffs fraternity believes in you, Your Excellency. In fact, they love you so much. And this is why we said that we have one resort. We have one person who can help us, one person who can bang the table, and it is none other than Your Excellency. We surely believe in you, we trust you. And as the executive of Uganda Court Bailiffs Association, we commit ourselves to work with you in any situation, in any case, in case the need arises of, if there is anything we can do as the Bailiffs fraternity, we really commit ourselves so much. Yeah, we really commit ourselves. And as I said earlier, we are invisible, but we are following Your Excellency. And I must thank you so much. I would have started by congratulating you, Excellency. But nonetheless, I thank you so much. I have, the little time we have been in the chair, I have really seen the fruits. I've seen the style, starting with, I saw the General Court Martial thing. I won't go there, but I know you've started on it, and I surely believe you do us a service. May God bless you so much. Thank you. Let's allow this to I'm not a good Luganda speaker, but he can try. I thank you so much.
For the purposes of Luganda media, I want to give highlights in Luganda. Basebo ne banyabo nga babeirifu beba wanyondo ba kooti. Judiciary eina gye bayita Rules Committee. Rules Committee etulwako chairman nga ye Chief Justice. Einako Attorney General, einako President wa Law Society, einako Director wa LDC, einako ne Principal Judge, Chief Registrar abeeranga Secretary waayo. Naye abantu abo nga bwe mbogedde baatuula ne bakola etteeka. Etteeka lye baakola tebabeera guided by the Constitution. Irwiru yabaguidinga, irwiru zinagwe nkyogera mu Luganda. Irwiru yabaguidinga nga baagala just kupanisinga babeirifu. Bakikola tebategeeza nti baagala graduatinga babeirifu. Naye bali baagala kubapanisinga. Kati nabo kibatuddemu lwa nsonga. Lwaleero ennaku z'omwezi 16 terina license yafulumye. Bitandise okubeekubyagana bokka na bokka. Amateeka geekubagana n'abantu. Nabo tibalina engeri gye bafulumya license. Kati saawa eno kaakati tewaliwo bailiff alina license. kubanga nabo tebalaba teeka lye bagifulumizaamu. Etteeka lye baafulumya January 22, 2022 si lye baateeka ate mu gazeeti baasimagolingayo lirala. Kati amateeka abiri gakontana, kati nabo bibatamye bibalemye. Naye twali tusaba Pulezidenti wa Law Society atuyambe nga bw'atuula ku kakiiko ako atuuse eddoboozi lyaffe, kubanga ffe Chief Registrar yagaana okutulaba, Chief Justice yagaana okutulaba. Twakola petition wa Chief Justice, President agendako kopi, yagaana ogiddamu. Ne tukola ey'okubiri n'agaana ogiddamu. Ne tukola petition bbiri mu Constitutional Court. Constitutional Court erina mandate egamba bwe wabeerayo petition ya Constitution ereka emirimu gyonna n'etunula ku eyo. Naye kati myaka 3 tetuulanga kutunula ku gundi eyo, ne tubawandikira amabaluwa ne tubakolera buli kimu kyonna, ebintu biganye. Kati ne tulaba radical new bar eyinza kutuyamba, ne tujja ne tugituukirira etuyambe. Mukama waffe Pulezidenti tuli wano ku maviiviigo tweyanziza.
Thank you. Jackson Mwesije, the Vice President of Bailiffs. And the importance of this matter is they never consulted the stakeholder. They just started. Thank you so much. Yeah, thank you.
Society last year, when we saw it, Mr. Arthur Isiko to give our response to all your able submissions. I specifically sought out Mr. Arthur Isiko because the business of bailiffs goes to the heart of advocates' revenue, advocates' resilience, and advocates' representation. You are in charge of the end of the river processes for whatever we start. You are in charge of keeping the Lord Mayor alive over a career of more than 20 years. Those who are starting to practice law, I hope you can share the pain. Mr. Ramkaga, you can please come. You came with your daughter last time, and your wife. Are they still here? She's at school. But your wife is here. Please come for the world to recognize you. Please. She's also a court bailiff. Come this way. Let's take a photo. Thank you very much. Thank you very much. You can introduce yourself to our members online.
Thank you, everybody. I'm called Fatuma Fazal. I'm a court bailiff for 18 years. I want to thank Mr. President for everything he's doing for the bailiffs now. We are in a crisis, and we pray for the Chief Justice to handle our issue urgently. We pray for that. Thank you, Mr. President.
Thank you very much, Fatuma. I didn't know women can do this job.
Yeah.
Thank you very much. And that's a very good testimony and example and model for our young girls and young women. Mr. Isiko.
Good morning, everyone. Allow me to stand on the protocol already laid down by the former speakers, but precisely allow me to recognize His Worship, the Lord Mayor of Kampala, capital city. Allow me to recognize the President of Uganda Law Society, the Vice President of Uganda Law Society, the President of UCBA, that is Uganda Court Bailiffs Association. This issue really touches us, the lawyers. As you all know, we all have an inclination, we all have an attachment on court bailiffs. Like the President has already stated, the bailiffs are at the end tail of the legal system. For those of you who do not understand what I'm trying to say, that once a litigant gets a court judgment, it is the bailiffs that execute. It is the bailiffs that go and enforce the judgment or the ruling of court. So that is how bad the situation is currently. Many lawyers have a bearing with bailiffs. As you all know, some of us, especially me in particular, my dad was a bailiff. I am what I am currently because a bailiff out there did his job and I went to school. And I do recognize very many bailiffs. I've actually seen most of them, especially Mr. Mukanga and company. I do recognize your presence here. As Uganda Law Society, we do understand the grievancy of the bailiffs, and it is on that basis that we have come up with a response. Allow me wish you all a happy new year. As a society, we again gather today under a shared commitment of rule of law, justice, fairness, and the continued growth of our legal profession. It is with respect for these principles that we address the petition submitted by the Uganda Court Bailiffs Association to the Chief Justice of Uganda, Honorable Justice Owinji Dolo, concerning the implementation of Rule 81B and Rule 28.3 of the Judicature Court Bailiffs Rules, that is under SI number 53 of 2022. The bailiffs have clearly stated that the previous SI didn't have an issue concerning the 2-year study extension or the study leave that was granted to the bailiffs. To their surprise, when they gazetted, they smuggled the issue of the 2 years. That is quite unfortunate. It is very regrettable because it has created this situation. The petition has been signed by over 289 out of 410 members of UCBA. The petition we are talking about has been signed by almost half of the bailiffs. Imagine, members of the Uganda Law Society, that a law comes up and almost half of us, our future is in doubt. It is the situation that the bailiffs are currently facing right now. This reflects a collective concern over the looming implications of the impugned provision. These rules, effective as of 31st December 2024, require all bailiffs to hold at least a diploma in law from Law Development Center as a prerequisite for the renewal of their license this year. UCBA members, that is Uganda Court Bailiffs Association members, argue that if this instrument is implemented in the current form, these provisions would impose chilling, restrictive, unreasonable, and unjustified prohibition on their practice. They contend that the rules risk stripping them of their accrued professional and economic rights, violating principles of fairness enshrined in the Constitution. As you have all heard, the bailiffs have said, they're not saying that they're not going back to school. In fact, almost a third of them, if not more, have gone back to school. In fact, majority, instead of pursuing the diploma, have even pursued the bachelor itself. Yeah, this is how interested now the bailiffs are into this matter. So basically, they are requesting that more time is granted to them. It is on this note that we appreciate that historical context. Previously, the requirement for bailiffs as a certificate in law from LDC, a standard which balanced access to the profession while ensuring adequate legal competence, the sudden shift to a diploma with retrospective effect disrupts the settled expectations of many seasoned practitioners. Majority of the practitioners, the bailiffs, especially that are in the premises of Uganda Law Society, are seasoned practitioners. They've been here for more than 20 years. They have gained the experience. They know what they are doing. So unfortunately, right now, they are saying that these people are no longer capable. Yeah? They're chasing them. It is the old broom that knows how to sweep better. Yeah? And they are saying also the retrospective effect. Yeah? This shouldn't apply to the already seasoned practitioners, the bailiffs who have been around. Yeah? If it is an issue of improvement of the academic standards, at least it shouldn't go backwards. Let it go in forward. Yeah? So Uganda Law Society stands firmly on the principles of rule of law, access to justice, and non-discrimination in the professional practice. We believe that any professional regulation must be rational, proportionate, and fair. It is imperative that regulatory changes do not unfairly disadvantage those who have already established themselves within the profession under prior legal frameworks. The Constitution of this country guarantees the right to practice in a lawful profession and engage in gainful economic activity without unjustified interference. Article 40 in particular of the Constitution safeguards the right to practice a lawful trade or profession, while Article 28 emphasizes the right to a fair hearing. Imposing a retroactive educational requirement without adequate transitional arrangement infringes on these rights and amounts to a denial of procedural fairness. As Uganda Law Society, we are saying the bailiffs, the current bailiffs, should have been consulted. That is the bedrock of justice, fair justice, natural justice. That before any decision is taken affecting an individual, such an individual should be given a right to be heard. They should listen to the bailiffs. Moreover, a sudden implementation of these requirements raises a significant access to justice concerns. Bailiffs play a crucial role in the enforcement of court orders, a fundamental aspect of rule of law. Restricting their practice through unreasonable qualification could disrupt the enforcement process, delay justice delivery, and impact marginalized groups who rely on timely enforcement of judicial decisions. So the society, we are saying that if the law is implemented as is, the litigants down there are going to be affected. Remember, they have their court judgments, they have their rulings in their hands. They are now calling their bailiffs. Bailiffs, the year has begun. Please enforce my judgment. And the bailiff is saying, you know what? I have no license. Yeah, I have no license. Why? Because the government has said, I am no longer experienced enough, I am no longer qualified enough to do what I've been doing best. So, one, it has an economic impact on the nation, but it is also affecting justice, access to justice by the marginalized community. Yeah, someone has had to go through the court process for more than 10 years. He now gets his judgment in 2024, and you're telling him he has to await the decision that will be made by the Rules Committee. That is so unfair. As Uganda Law Society, therefore, we recommend the following. These are the recommendations of Uganda Law Society in respect to this matter. We are calling upon a transitional arrangement. By this we mean that bailiffs already practicing under previous certificates should be granted reasonable grace period to upgrade their qualifications without losing their license. Number two, recognition of experience. Like I've already said, the old broom knows how to sweep better. Long-serving bailiffs with demonstrable experience and competence should be exempted or provided with alternative compliance mechanisms. Lawyers, we have what we call CLEs. Yeah, every year, there's special sittings we go through and they help us enhance our understanding, current understanding of the law. the government should come up with something similar. They should benchmark from Uganda Law Society so that bailiffs can upgrade without even naturally going to upgrade. Of course, we understand they upgrade, and I know very many of them are upgrading, but such a mechanism, alternative compliance mechanism, should be put in place for bailiffs. Number three, dialogue and stakeholder engagement. We are calling upon government to engage the members of Uganda Court Bailiffs Association. Engage these members. They will give you a clear picture of the challenges that they are facing, and probably you'll come up with a way forward. Review and harmonization. The judiciary should review the rules to ensure they align with the constitutional guarantees and principles of proportionality and retroactivity. We all know that a law shouldn't work backwards. So we are telling the government, please comply. If people are to be affected, it should be the new entrants that should be affected. So on behalf of RNB, the Radical New Bar Governing Council, we do commend. We commend you, UCBA, for choosing a constructive dialogue as a means to address these concerns, and for utilizing this platform of Uganda Law Society to engage with the judiciary. Their petition, the one you just presented, will be presented alongside other concerns. We have other concerns that we shall be tabling before the Chief Justice during our next call of engagement. Thank you for listening to me. Basically, that is our response to your issues as bailiffs. Allow me to call upon the CEO to take us to the next agenda.
Thank you, the representatives from the Uganda Court Bailiffs Association for their petition. It has been heard, and the President has also listened in very carefully, and I'm very certain he's going to support. Thank you, Treasurer, for your submission. I now take this opportunity to invite the Vice President of Uganda Law Society to give us the ULS position on the court case as census. You're welcome, Mr. Vice President.
Thank you, Madam CEO. The President, ULS, Mr. Isaac Semakade, the President, Uganda Court Bailiffs Association, together with your team, welcome to ULS House. The Lord Mayor, who is also our member, Uganda Law Society, the Treasurer, the ULS members who are here present and those online, members of the public who are listening in and those watching, and the members of the media who are here. You're welcome and thank you very much. As you notice, we've been having a break from court because of the court census, which has been happening between 13th and 15th of this month. And please allow me present our position, the ULS's position on the recently concluded judiciary court case census. We take note of this court census, which has just been concluded. It took place from the 13th to 15th of January 2025 as an instrument to tackle case backlog and design justice interventions in Uganda. While such initiatives as this one may appear commendable, we categorically, as Uganda Law Society, demand answers and accountability for the glaring lack of tangible outcomes from similar efforts in the past. This is not the first time this has been done. It's been done in the past. But what we demand for is accountability and action taken from the outcomes of that activity. The first judiciary court case census was conducted in 2015, after which the Case Backlog Reduction Committee released a detailed and actionable report outlining strategic proposals to eradicate case backlog. Despite a significant investment of resources and time in this project, recommendations from the report have been shelved and ignored. The recurring pattern of conducting studies and launching interventions without implementations is wasteful and betrays public trust. It takes time, resources, and the public will not believe in this activity, or in this process, if we do not see the results of conducting such activities. The Sectoral Committee on Legal and Parliamentary Affairs rejected increasing judicial officers as a solution to case backlog in 2023 Judicature Amendment Bill. Instead, it proposed practical alternatives such as limiting the Supreme Court's jurisdiction to only matters of law, establishing a court sieving system, and reviewing the pecuniary jurisdiction of magistrates' courts, among others. This included the decriminalization of poverty, looking at petty offenses. Now, these recommendations remain largely unaddressed because they've not been taken care of. Section 18 of the Administration of Judiciary Act Cap 4 of 2020 mandates a performance management system to track judicial officers' output. Despite its potential to ensure accountability, this system has never been established. We are still waiting for it up to now. The Judiciary Performance Enhancement Tool launched at the 2019 Annual Judges Conference was designed to assess judicial officers impartially, yet its adoption remains minimal, and the judiciary has failed to ensure its effective utilization. This is also another recommendation that came out of that activity, which is yet to be implemented. Its implementation is really at a lower level, and we are not seeing the results. We are not seeing an outcome out of this intervention. The judiciary must confront the root causes of its inefficiency, accountability, and judicial performance. We have nations with larger populations, like the United States of America. Its population is over 335 million people. But it manages their caseloads with far greater efficiency in comparison to Uganda's population, which is only 48 to 49 million. Think about that. We condemn this cycle of inaction and lack of implementation, which has consistently hindered access to justice. The recently concluded court case census risks becoming yet another futile endeavor unless accompanied by a concrete and transparent implementation plan. We therefore demand measurable action, starting with the immediate operationalization of performance management systems and prioritizing of meaningful, efficient interventions. The focus must shift from ensuring that judicial officers work efficiently and uphold their responsibility to deliver timely justice. It is not enough to keep conducting these activities, to keep coming up with such, interventions, which are good on the face of it, but do not yield any results. And as ULS we say, that has to stop. We need to see results out of the interventions that are being taken up or that are being adopted by the judiciary. So we do demand that we have reasonable outcomes that are visible and tangible. I thank you very much for listening. Now, for the members of the public who may not understand English, I want to try and, reduce it to the Luganda version, hoping the bigger part of the population will understand Luganda. I know Uganda is a multilinguistic country, we have so many languages. I could have put it in very many of them, including Acholi, Langi, Lugbar, and many others, but I'll do Luganda for purposes of a bigger population. Nti chino oba eno ye position ya Fenga Uganda Law Society ku ensonga ezibadde mu judiciary oba mufuga mu kitundu ekyabalamuzi mwakitegedde nti ennaku eziwedde emabega eziyiseeko okuva nga 13 mpaka nga 15 emirimu gya kooti gyayimirizibwa ne babategeeza nti judiciary oba esiga eddamuzi bali mu kukola embalirira oba okubala emisango egiri mu kooti. Nti omugaso gw'ekintu kino kyateekebwawo okutegeera n'okugezaako okufuna engeri gye bayambamu oba gye bakwata gye basolvingamu obuzibu obw'emisango egirwa mu kooti. Nti mu makooti mukimanyi nti emisango mingi nnyo oba kye tuyita case backlog, nti emisango tegitambula. So kooti oba esiga eddamuzi bagezaako okunoonya kye tuyita solution oba tugezaako tutya okutaasa embeera eno. Y'ensonga lwaki bakola embalirira eyo nti bategeere ekiri mu kooti, emisango egiri mu kooti lwaki girwayo, nti oluvannyuma bakole enteekateeka oba okusinziira okunoonyereza okwo oba embalirira eyo bategeere ki ekirina okukolebwa okugezaako okutaasa ensonga eyo. Kinaye Fenga Uganda Law Society tugamba nti wadde ekintu kirungi nnyo, wadde enkola ezo ezijja nga ey'embaliriro oba eya census nungi nnyo ng'ogitunuulidde, naye kyetugamba nti tekirina makulu gekikola okuteekawo enkola ng'ezo naye ne tumaliriza nga tetulina kyamaanyi kyetufunyeemu lwansonga nti ssente nyingi zigendamu obudde n'ebiseera, naye ate n'ogenda okwesanga nga ebivuddemu mu nnaku ezo oba mu nkola eyo tekirina kyekikoze kyetutuyambye. N'olwekyo kyetusaba ffe nga bannamateeka wanga Uganda Law Society tusaba nti judiciary oba esiga eddamuzi batuwe baddemu ebibuuzo ebingi abantu bye batalina ansa bye batalina kuddibwamu nga batunyonyola ebivuddemu enkola nga zino ze bakoze naki kye bakozeewo okusinziira ku bye bajjamu. Si gwe mulundi ogusoose, enkola eno yakolebwako mu 2015 era okuva mu nkola eyo ne bateekawo obukiiko obw'enjawulo. Waliwo komite yateekebwawo eyitibwa Case Backlog Reduction Committee nekola report ng'etuwa enteekateeka ez'enjawulo ze baakola okulwanisa oba okuggyawo emisango okulwawo nnyo mu kooti. Nti wadde obudde ne ssente byagendamu, akakiiko kano proposals ze baakola oba bye baasalo bye bawandiika nti bye birina okukolebwa byaterekebwa, tebyateekebwa mu nkola. Ekitegeeza nti kyekina kye kyayamba omuntu wa bulijjo oba okulwanisa ensonga eyo. Era bino bize bigenda mu maaso nga n'abamu baleeta okunoonyereza kuleetawo embeera oba enteekateeka ez'enjawulo ziyinza okukolebwa. Waliwo komiti ya Parliament gye bayita Sectoral Committee on Legal and Parliamentary Affairs yali yagaana enteekateeka okusaba okwongeza abalamuzi mu Judicature Amendment Bill eya 2023 era yo neeragira oba neewa obuwabuzi neewabula akakiiko ako ne kawabula ku ebisobola okukolebwa ebirabika nti biyinza okuyamba ensonga eyo nti okwongeza abalamuzi oba omuwendo gw'abalamuzi kyokka tekimala okugyawo ensonga y'emisango okulwawo mu kooti lwa nsonga nti si nti lwakuba abalamuzi batono si kye kyokka ekiviirako emisango okulwawo nnyo mu kooti nti era okuwabula kwe baawabula okukendeeza ku emisango egigenda mu Supreme Court babeere nga emisango Supreme Court gyekolako gibeere nga gyemisango egikwata just ku mateeka oba ku nsonga ey'okutafuta amateeka n'ensonga ezitafuta amateeka ne bawabula n'okuteekawo enkola mu kooti oba mu system y'amakooti okwongeza oba okuyambaku okulagira emisango oba kye tuyita jurisdiction kooti eza wansi oba magistrate oba abalamuzi awansi emisango egirina okugenda mu kooti n'egitalina kugendayo naye obuwabuzi obw'akakiiko ka palamenti bwe kaawa nabwo tebwateekebwa mu nkola babuleka bulesaawo tebulina babulanga obutayamba nti akawaayiro 18 aka Administration of Judiciary Act Cap 4 eya 2020 eragira nti wabeerewo enkola egoberera oba etrackinga omulamuzi ng'omuntu enkola ye n'obuweereza bwe oba kye tuyita output nti omulamuzi ng'omuntu nga ye tulina system wabeerewo system etrackinga oba eraga muntu gy'asobola okubeera neera nti ono omulamuzi obuweereza bwe buli butya awuliza atya emisango mu mwezi oba mu mwaka akola judgments meka nti oba awuliriza emisango emeka gy'amaliriza kuba kyazirwa nti waliwo abalamuzi ababeerayo n'amala n'omwaka nga takuwanga n'ensala y'omusango n'etya n'emu so etteeka eryo lyalagira oba lyateekawo eyo enkola naye eno system oba ensonga eyo naye tekolebwangako eyo system teteekebwanga mu nkola ate nga yandibadde ng'eyamba ku kintu ekyo ky'emisango okulwawo mu kooti okutundira ku mulamuzi ye ngaki ng'omuntu kuba tukkirize nti waliwo abakola waliwo n'abatakola ki n'abatakola so ffe kye tugamba twaliwo ne judiciary performance enhancement tool oba tool judiciary yennyini gyakola beesiga eddamuzi nabo bakola tool yaabwe mu 2019 gye bayisa nga wali mu lukuŋŋaana lwabwe lwa 2019 nga era tool eyo nga nayo yaku guiding oba okulaba okutunulira omulamuzi ng'omuntu buli mulamuzi nga sekinoomu enkola ye mu bwenkanya naye eno tool naye yennyini gye baakola oba gye baayisabo ng'ekitongole ekiramuzi ate naye eyo tool yennyini naye tebakola ki tebagikozesa nga yandibadde bagikozesa eri awo ekola mpola mpola era ekitongole kyennyini kiremereddwa okukozesa ekintu ekyo kye baateeka mu nkola okugezaako okuyamba oba okutaasa ensonga ffe kye tugamba nti esiga eddamuzi oba kye tubasaba kye twogera ffe nga Uganda Law Society nti kyandibadde kitunulira ensonga eziviirako emisango okuba nga giriwo mu kooti nga miyitirivu tegigwa gyeyongera bweyongezi bandibadde nga batunulira ensonga eziviirako ekintu ekyo kiva ku ki okusanga ng'emisango miyitirivu si kutandikira waggulu wabula kutandikira okutunulira ensonga ekiviirako emisango egyo kubanga tegiva mu kooti n'okulaba enkola oba obuweereza bw'ekitongole kyennyini bo ng'ekitongole beeratinga batya balaba nti obuweereza bwabwe bwatyo bwe bandibadde baweereza wekisaanidde nti waliwo amawanga galina abantu bangi nnyo okusinga ngaffe Uganda bw'otunulira nga eggwanga nga United States bali mu miliyoni 335 naye ekitongole ekiramuzi nabo balina emisango bagenda mu kooti naye balina enkola bwe basobodde okuba nga tebalina misango girwawo mu kooti lwakuba bateeka mu nkola systems oba obuweereza obusobola okusolvinga okugyawo ensonga eyo naye ate fano Uganda tulina abantu miliyoni 49 bokka ate ffe tulimu atuti oba tulemererwa tutya okuhandolinga ensonga eyo ate nga si nti ku bantu bonna 49 bagenda mu kooti eyo population ya Uganda naye ate abagenda mu kooti bw'otunulira ne report gye basembayo otuwa mu Uganda yonna bali percent 10 oba 10%. So ekitegeeza ku 49 the 10% oba obutundu 10 ku 100 kwabo abagenze mu kooti batute emisango gyabwe mu kooti nagyo giremeddeyo gyeyongera okuba mingi. So ffe kyetugamba nti tuvumirira oba kyetutakkiriziganya nakyo kwokubeera nga enkola ze bafuna oba okuwabulwa tebakuteeka mu nkola wabula okukola bukozi ebintu ng'okugenda okubala emisango egiri mu kooti okulaba gyenkanawa giri emeka lwaki giruddeyo ate okuwabulwa okuva mu kunoonyereza okwo ne kutateekebwa mu nkola kyetuvumirira era ekitweraliikiriza nti neeno judicial court census ewedde oba enembalira y'emisango mu kooti ewedde eyinza okuddayo ku kintu kyekimu ekyemabega nga kyetwayitamu nti wabeewo okubala ennaku nga 3 kuva 13-15 baweereze ebivuddemu naye ate kibeere nga tekirina kyamakulu kyekikola kyekituyamba nga webize bibaawo emabega. So kyetusaba oba kyetukozesa ekigambo demand nga Uganda Law Society nti judiciary oba ekitongole ekiramuzi bakole oba bateeke mu nkola batandike okukozesa okuteeka mu nkola ebintu oba solutions ebivaamu ekintu ekirabika oba ebintu ebirabika nga twayogedde ku performance management system yali yayogerwako nti ate ne kyebandibadde basaako amaanyi oba basaako amaanyi ze solutions oba ebintu ebisobola okuziyiza oba okugyawo ensonga eyo gyetugezaako okulwanyisa wabula si kugenda mu maaso n'okukola bukozi ekirabika nti kikolebwa naye nga tekivaamu mulamwa tekirina kyekituyamba oba tekiyamba nti twandibadde nga oba nga judiciary yandibadde etunulira nnyo okulabika nti abalamuzi mu sisitimu yaabwe basobola okukola obulungi nga batuusa obuvunaanyizibwa bwabwe mu biseera ebyetaagisa. Teri nsonga lwaki omuntu ateeka omusango mu kooti n'omala emyaka 10 emyaka 2 nga gukyali mu kooti. So ffe nga Uganda Law Society bwe tutyo bwe tulowooza ku nsonga eno oba eyo position yaffe ku nsonga ebaddewo ya judiciary court case census oba okubala emisango egiri mu kooti. Tweyanziza mwebale tuwuliriza.
Thank you, Mr. Simwe, the Vice President, for giving the position of Uganda Law Society on the recent court case census. Now I take this opportunity to invite Mr. Lukwago Elias, the Lord Mayor, to come and present a petition on behalf of the legal defense team. We all know that they're defending retired Dr. Kano Kiza Besige in the case where they were arrested recently and appearing at a general court martial with Haji Obed Rutale Kamlegea. Thank you, Your Work.
Excuse me, the President, Uganda Law Society, members of the Executive Council, all of you, dear participants, members of the press. I salute you, Mr. President, and your team, and permit me extend our warm blessings from the entire team, as well as greetings. We wish you a blessed 2025. Mr. President, before I present to you the petition, allow me to extend our sincere gratitude to you for the interventions that you made at a time when we are struggling to secure the temporary practicing certificate for the senior counsel, Martha Karua, who is the lead counsel. We do appreciate all your efforts that you put in that matter to its logical conclusion, where we finally secured the certificate, and now the entire legal team is fully constituted, with Martha Karua having audience before the court and taking charge of the legal team. We thank you for your timely intervention and all the efforts you put in. Thank you, Mr. Mr. President. Mr. President, this morning, it's now red afternoon, Senior Counsel Martha Karua ought to have been here to present a petition on behalf of the entire legal team, but she had to travel back to Nairobi, and I was assigned this duty of presenting the same for and on behalf of the team. And with your permission, allow me proceed to give key highlights. It's a plea for support on legal and human rights violations which are happening at the General Court Martial. The background to this matter is that Colonel Dr. Chizaves was abducted from Nairobi on the 16th day of November last year, where he had traveled to attend the book launch for Senior Counsel Martha Karua, earlier on scheduled for 17th of the same month. However, Mr. Chairman, it was not possible for him to attend because on the 16th day, he happened to be in a meeting at Riverside apartment in Nairobi, where some unknown security operatives, believed to be part of the security apparatus from Uganda, kidnapped him and whisked him away back to Uganda here without going through the immigration protocols and without following the due process, including violation of the extradition laws of Uganda and Kenya, as well as other international law regarding transfer or extradition of people believed to have committed crimes. And he was detained in a military facility here in Kampala and subsequently charged with a return of offenses before the General Court Martial, together with Obed Lutale. Legal and constitutional concerns. We contend that Article 126 of the Constitution of the Republic vests judicial authority in the courts of judicature and other subordinate courts. While the General Court Martial is an establishment of the Constitution and other laws of Uganda, it's our strong contention that the provisions of the UPDF Act 2005, granting it jurisdiction over civilians has faced significant constitutional challenges. Mr. President and your team, I'm sure you take cognizance of the fact that there are quite a number of decisions handed down by the Constitutional Court on this particular matter regarding the jurisdiction of the General Court Martial over civilians. Not one, not two decisions, but a couple of them. We have raised these concerns and all these issues before the General Court Martial, but all in vain. Notwithstanding these concerns and other horrendous transgressions, the court has continued with the proceedings, creating a very contentious legal atmosphere, not only in the General Court Martial, but in the entire criminal justice system. Now, Mr. President, I'll speak specifically about the Aaron Ichiza incident. On January 7th, 2025, one of our colleagues, Aaron Ichiza, no, allow me to repeat this, Mr. Chairman. On 7th of January this year, Aaron Ichiza and other defense lawyers entered the courtroom. Ichiza was obstructed from accessing the bar by a court orderly. This was done in full view of the court chairman and the entire members of the panel. And Mr. Chairman, the court orderly physically assaulted Ichiza, harangued him, mauled him, and was joined by other soldiers and security operatives who brutally dragged him out of the courtroom. Mr. Chairman, the General Court Martial subsequently subjected him to summary, it's not even a trial, but just sentencing. And he was whisked away and taken to Chitalia to serve a sentence of 9 months for what they allege to be an act of contempt of court, and referring to incidents that had happened earlier, not only on that fateful day, but even incidents which had happened earlier. As a defense team, we contend that this obstruction and assault were premeditated and intended to provoke Aaron Ichiza and ourselves to provide the grounds for punitive action which was taken. And it was quite obvious, Mr. Chairman. We all witnessed the proceedings there as they unfolded, right from the point of interception, the arrest, the dragging, the haranguing, and finally the sentencing to 9 months in total violation of not only the UPDF Act, which talks about a maximum sentence of 30 days, but also the Bill of Rights in Chapter 4 of our Constitution, which dictates in Article 28 that all accused persons are entitled to a right to a fair hearing. He was not at all heard. And despite the fact that, Mr. Chairman, under Article 44, that right is non-derogable. It's an absolute right. No circumstances should arise where one is deprived of the right to be heard. It's one of those rights which are entrenched in the Bill of Rights. The oppressive atmosphere in the courtroom has had a chilling effect on the entire legal team, and resultantly the defense law team has since shrunk to 23, down from 42. Initially we were 42, but as per the last appearance, we were only 23. Largely on account of the oppressive atmosphere in the court or the courtroom, which is regrettable. The impact on legal representation. This incident raises serious concerns about the safety and independence of the legal practitioners in Uganda. The International Bar Association standards, the UN basic principles on the role of lawyers, and Uganda's constitution and statutory laws guarantee a lawyer's right to represent their clients without harassment, threat, or any kind of intimidation. The obstruction and imprisonment of Aaron Chiza violates these principles and jeopardizes the accused's right to legal representation by a lawyer of their choice. This is another entrenched provision within the Bill of Rights in Chapter 4, where an accused person has got a right to legal representation and to have a lawyer of his choice. Now, Mr. Chairman, that is the summary of what is happening there, and without wasting your time, permit me proceed to the call for action. What is our request, Mr. Chairman? The continued detention of Aaron Chiza undermines the rule of law and the fundamental rights of both lawyers and their clients. We urge the Uganda Law Society, human rights organizations, and the international community, but specifically here for the request to the Uganda Law Society is as follows, Mr. Chairman. One, Mr. Chairman, to amplify the voice against these violations of not only the municipal laws, but international laws and instruments to which Uganda is a party, which Uganda has assented to. It's our humble request, Mr. Chairman, that the Law Society, as a vanguard of rule of law, should be at the forefront of defending these rights, should be at the forefront of challenging this kind of transgressions, should be at the forefront of dealing with this horrible situation. We specifically request that, Mr. Chairman, all interventions be explored to cause the immediate release of one of our own, Aaron Chiza. It is our request that we do everything possible to get justice for Aaron Chiza, who did nothing but to assert the right of an advocate to represent their clients before the General Court Martial. He was just asserting his right, his duty as a practicing advocate to represent their clients. We know there are a number of options that can be explored, Mr. Mr. President. You'll excuse me where I come from. I've always been practicing before General Court Martial, where we have chairman. And I'm infected now, Mr. I'm worried if I go back to the civil courts, I may address the Chief Justice as Mr. Chairman, because this is really infectious. Mr. President, we believe the Law Society has capacity to cause the release of our colleague, to defend him under all circumstances. Number 3, we also requested that, Mr. President, again, the Law Society comes out to offer us all the necessary protection to be able to execute our duties as lawyers before the General Court Martial. The atmosphere there is hostile. The environment is not conducive at all for dispensation of justice. If anything, Mr. President, whatever we are doing there, it's like we are escorting Dr. Chizabesji and the team to the gallows because the offenses they are charged with carry a maximum sentence of death. The first one under Section 128 of the UPDF Act, which is compromising security of Uganda, and the most recent one, which they added onto the charge sheet. When they amended the charge sheet, they added on the offense of treachery. Those 2 offenses carry a maximum sentence of death. And whatever is happening there, every application we have put up, every prayer we have made has been frowned upon. Actually, right from the time we started, right from the time they took a plea, right from inception, Mr. Chairman, that is last year, we have had occasion to appear several times, and we have made several applications. None of those applications has gone our way. We have lost all of them. A clear indication that we are indulging in an exercise in futility, that we are not actually going to receive fair trial or fair hearing there. Mr. President, our noble profession is under threat. The entire criminal justice system is being bastardized by the General Court Martial. Whatever is happening there, by the way, Mr. President, is a negation of the due process, which is well provided for in our Constitution. So, it's the reason, Mr. President, we ask for the intervention of the bar to ensure that there is fair hearing. And also, Mr. President, to stick to the position given by the traditional civil courts, particularly the Constitutional Court, that court is a disciplinary committee for serving members of the UPDF. And this is now the specific call we are making in that regard, that the radical bar, Mr. President, should be at the forefront of pursuing all available legal measures to bring to the halt the abhorrible practice of subjecting civilians to martial law. Mr. President, this practice is despicable, is reprehensible, is abhorrible. That non-serving members of UPDF civilians are subjected to martial law. This morning I was listening to the news, Mr. President. The whole president of South Korea has been finally arrested for attempting to institute martial law in South Korea. He's been arrested. Why are you instituting martial law? We are all candidates for court-martial action. Mr. President, personally, I'm a convict. Personally, myself, I'm a convict of the General Court-Martial. And I will carry that record all through, because all options of setting that record aside have come to a naught. So throughout my lifetime, my career, until I'm interred down there, I will carry that record of being a convict of the General Court-Martial. I've never been convicted by any other civilian court. The only conviction I carry is that of the General Court-Martial, and it haunts me. You and members of the bar are not safe either. So, Mr. President, it's the reason we are making now, this is the final call, which sums it up all. That we do invite the radical bar, Mr. President, we do invite the radical new bar to bang tables for the rule of law to prevail. We are convinced beyond all shades of doubt that it's time to bang tables for the General Court-Martial to stop this madness. Otherwise, the entire criminal justice system is going to be bastardized, distorted, and in the end, the entire rule of law will be subverted, and that will be an absurdity. So we must bring an end to this travesty which is going on before the General Court-Martial, exploring all the available mechanisms within the law. We thank you, Mr. President. May God bless you. If you may permit me, Mr. President, to hand over this petition to you. If it pleases you, Mr. President, this is our petition for the request. We do so pray. Maybe prayer yoka. Tusaba, Mr. President, ne olukiiko lwo okulaba nti Uganda Law Society eweebwa obuyinza mu Uganda Law Society Act eyingira mu nsonga zino nga bwebadde ng'ejja erwanagana n'ensonga zino okumala ebbanga okulaba nti olugendo luno tuluggusa olw'okuteekawo embeera ey'obwenkanya. Mu General Court-Martial gye tuli, Mr. President, teriiyo bwenkanya. Environment yonna oba embeera eriyo ya busibira mu bbwa yakututwaliriza tuwerekere Dr. Besigye ne munne ku kalabba kubanga emisango gye baba baguddeko singa gibakka mu vvi etteeka ligamba gyakubatwala kalabba. So bwe tulaba ebigenda mu maaso buli ka application konna ke tuteekayo buli nsonga yonna gye tuteekayo bagikasuka mu kasero. Kooti ne banne bonna chairman ne banne batutunuulira nga ffe abatalina mugaso. Ensonga zonna ze tuteekayo ez'amateeka ziziimuulwa buziimuulwa. Kakati kyatuuse ensonga zaalinnyo enkandago bwe gwajja bagidde nga Aaron Kiiza munnaffe bamukutte ne bamuyisa ng'ekyonziira ne batamala namuwozesa naye ne bamuteeka mu komera ekitalya okumala emyezi 9 ng'ate etteeka lya PDF Act liga nti maximum sentence eyinza kuba ya nnaku 3 nga tawozeseddwa. Kakati waliwo embeera ey'okutiisatiisa balooya era okusooka twali balooya 42 kati we tutuukidde wano tusigadde 23 nga ttiimu y'abalooya abamu batiisiddwa abalala bakooye ne bagamba ebyo ebya General Court Martial tebigasa. Mr. President, nze njogedde ne ba senior lawyers bangi nnyo nga bagamba nti eyo tetukyadda ffe eyo tetukyadda mu General Court Martial. Mr. President, nange nali omu ku abo abaali bateekinze decision nga nti mu General Court Martial sikyaddayo. Naye kati kino bwe kyatuuka notugamba nti nunno katugende tuteekewo olutalo olulaba nti wabeerawo obwenkanya. Kati tujja kusaba Mr. President ne executive kisooka Aaron Kiiza bamulanga bwemage yali akola mulimu gwe nga looya era ne bamukwata mu mbeera efaanana bwe tuso okusaba kwaffe kwakuga nti Law Society ejjeyo n'ag'omu buto okulaba nga tujja muganda waffe Aaron Kiiza ekitalya gye bamuteeka. Ekyokubiri ekisembayo kwe kulaba nti Mr. President buli kyonna ekisoboka tukikola nga radical new okugamba nti ekimala nti enough is enough. General Court Martial teri waggulu w'amateeka teri waggulu wa ssemateeka naye kati yo kyekola eragira ddala nti yo ssemateeka tagikwatako. Obuwaayiro bwonna bwe tusayitinze obuli mu ssemateeka ebusuula eri bbali bakwata bukwasi UPDF Act ne regulations zaabwe ssemateeka tabakwatako. Tewali nnyingo ya ssemateeka n'emu gye bakwatako bo ssemateeka bamufuula ng'ekipapula. So tugaa nti buvunaanyizibwa bwaffe nga balooya era kwe kusaba radical new ogamba nti tukube ku mmeeza okulaba nga wabeerawo obwenkanya wabeerawo enkola entuufu eri mu ssemateeka okulaba nti General Court Martial ekomya byekola kubanga ffe kyetugamba era kyetulemeddeko Mr. President ba civilians oba abantu ba bulijjo balekerawo okutwalibwa mu General Court Martial. So awo bwe kiba kisoboka okuba emmeeza okulaba nga ba civilians abantu ba bulijjo tebaddamu kutwalibwa mu General Court Martial. So lwe lutalo sematalo lwe tusaba Uganda Law Society okulemberamu. Tweyanzike.
Thank you very much, Ms. Adeti, our CEO, for helping us through this function. My gratitude goes to my colleagues on the Radical New Bar Governing Council, Mr. Vice President and Mr. Treasurer, for your service today, as well as our colleagues who are online, council members for Eastern, Western, and Northern Uganda, who couldn't join us on short notice because they will be joining us for important council business in the new week, over the weekend as well, actually. I would like, in a special way, to give gratitude to our secretariat team, led by Ms. Christine Awori. Yes. Thank you. Ms. Christine Awori, after this, please come. Ms. Christine Awori, our CEO, and our rule of law team led by Ms. Afra Apio, please come up for recognition. Please join me here. Mr. Gaudius Tuyasingura. Gaudius Tuyasingura. Yes. And Ms. Patience Gwen. She around. Yes. We would like to, from the Radical New Bar Governing Council, would like to appreciate you for your service. Much of the acclaim and flowers goes to us, but really you are the engine behind our service on behalf of the Uganda Law Society and the people that you work with. Yes, today is not the day to speak about our legal aid team, but I'm sure the presence of the CEO is sufficient recognition that we appreciate. Yes. My Lord Mayor, Your Worship, this is our rule of law team. As you see them, your petition is in good hands. You've done a great thing to recognize your cradle in Sibuku, to come back home. Charity begins at home, and we love it when our members recognize that the battle needs to be instructed in a formal way by members who seek its services in terms of Section 3C of the Uganda Law Society Act, our duty to protect, represent, and assist members of the legal profession as regards conditions of practice or otherwise. This is properly within our remit. Thank you for working here with great humility and divine purpose to hand over this matter to this 69-year-old institution. These JNCs are in charge now. You can go and see. Mr. Vice President and the Treasurer, our member and distinguished Lord Mayor for Kampala Capital City Authority, greetings. This is to present our statement on the General Court Martial in light of this petition you have presented this morning, which, as you correctly stated, was brought to our attention earlier on in some form by the lead counsel, Honorable Martha Karua, who we had the chance to meet as part of our consultation process at some point during your proceedings. It's sad that we can't have her here to present it herself, but you have done it justice. She covered almost similar ground when we met her, shortly before bedtime, one of those days you were in court at her residence. So, we have received another petition from the International Bar Association, the Human Rights Institute. And we have received similar calls from the Regional Bar Association, the East Africa Law Society, and concerns. I am in communication almost daily with the President and Vice President of the Society of Kenya to ensure the safety of their colleagues who are performing in Uganda. Behind Honorable Martha Karua, I understand there's a team of jurists, not only from Kenya, but across the world. And the proceedings at the General Court Martial have been of great concern for the International Commission of Jurists, which is housed in Kenya, the Kenya chapter. So this is not the only petition the society has received, and we are open to receive more petitions, and we assure the public that we will give these petitions treatment, the rightful treatment they deserve. Colleagues, on some day which is still being discussed, someday soon, possibly this month, I believe next week, I will lead a delegation, a high-level delegation of the Uganda Law Society to meet the Chief Justice of Uganda, Honorable Alphonse Chigamoy Owinidolo, this time on behalf of countless individuals and families whose lives have been torn apart by the lack of clarity on the legal framework governing military courts. This matter has plagued our justice system for nearly 2 decades, resulting in egregious, the worst form of violations of fundamental constitutional rights, and it demands immediate redress. The time for action is now. The Uganda People's Defense Forces Act, almost now well known as the UPDF Act, which commenced on the 2nd of September 2005, included Section 119, subsection 1, clauses G and H, which have been the subject of endless and chaotic interpretation by the judiciary of Uganda. This is what the UPDF Act provides in the aforementioned section. 119. Persons subject to military law. The following persons shall be subject to military law. G. Every person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense. Now, a person ordinarily subject to military law is a serving military officer. So this section 1G says that every person other than a serving military officer who aids or abets a serving military officer in the commission of a service offense will also be subject to military law, or what my senior colleague has called martial law. And H, every person found in unlawful possession of, item number 1, arms, ammunition, or equipment ordinarily being the monopoly of the defense forces. And item number 2, any person found in unlawful possession of other classified stores as prescribed. That, in essence, is section 119, subsection 1, clause G and clause H. Now, 42 justices in the Court of Appeal and Constitutional Court of Uganda, as well as the Supreme Court of Uganda, have spent a total of 25 years examining whether this section is inconsistent with Articles 28 Sub-Article 1, 126 Sub-Article 1, and 210 of the Constitution. In simple terms, 42 justices of the Court of Appeal, also sitting as the Constitutional Court of Uganda, and the Supreme Court of Uganda, the top court of Uganda, have taken 25 years of legal time examining one question: whether the trial of civilians in military courts is unconstitutional. Think about that. 25 years is the median age here at the Uganda side. So you saw Gwen before she was born. The judges were examining this issue. Now she's giving me advice as a member of the Rule of Law Department. And the judges are still examining this question. There is an interesting book for those of you who love literature by Charles Dickens. It's called Bleak House. Anybody who knows it and you get 100,000 shillings? Bleak House. It has an interesting opener. The case of jaundice versus jaundice. Judges have come and gone. Lawyers have come and gone. But the case of jaundice versus jaundice remains at preliminary stage. It was supposed to be about a simple issue. Who should benefit from this estate? Generations of the original beneficiaries have since passed on. But the record records adjournment after adjournment. No witness has ever been heard. You must understand now, if 200 years have passed, which witness is there to be heard on the original question of the will of the jaundice estate? I think this is where we are. The initial challenge, Constitutional Petition 18 of 2005. 2005. So this act was passed in September 2005. Do you know who moved first to challenge this particular provision? It was the Uganda Law Society. In September of that year, the Uganda Law Society challenged Section 119, subsection 1, G and H of the UPDF Act. In CP number 18 of 2005 versus the Attorney General. It resulted in a split decision by a majority of 3-2 in favor of upholding the constitutionality of prosecuting civilians in military courts. In Constitutional Appeal number 1 of 2006, the Uganda Law Society had filed a cross appeal. So which means that the Uganda Law Society challenged the UPDF Act extensively. It challenged so many provisions, not just this one. And it won on all those provisions except this one. So the government appealed on all the other provisions, and the Uganda Law Society filed a cross appeal on this particular issue and another issue, which again is important for you, trying civilians jointly with the serving officer. So I'm here to tell you, colleagues, that we are sorry. Our ancestors abandoned the cross appeal on this issue when Constitutional Appeal number 1 of 2006 was called. In the year 2008, I was a clerk then, a research clerk to Justice Katrebe. I witnessed the representative of the Uganda Law Society say those words. I abandoned the cross appeal on those grounds. I will name names. He was Senior Counsel Godfrey Rule. I accosted him at the exit and I said, why did you abandon that ground? Honorable Lord Mayor, Senior Counsel Rule told me, look at me, 79 years old. I have defended the appeal of government on almost 47 sections. I had no energy left in me to argue the cross appeal. When we began doing this case, Mr. Semakade, there were many young lawyers and senior lawyers with me. That was 2005. In 2005, there was a caravan of lawyers with me. Look around the court now. Who do you see? He asked me. I said, we are together. So he said, now section 119, subsection 1, clause F, clause G, and H will be for your generation to tangle with. Now, it is important to name certain names. In Constitutional Petition 18 of 2005, the record shows that Mr. Rule led a team accompanied by David Mpanga, Frederick Kisutu Mpanga, and Medad Segona. They were absent when Constitutional Appeal 1 of 2006 stand up to help him complete the circle. It is no coincidence that Medad Segona fought ruthlessly to win the Kabazigruka case to purge his conscience of his absence when Constitutional Appeal number 1 of 2006 came up. It is no coincidence. And we celebrate him for correcting his error. Please, take our gratitude to your partner. Take our gratitude to your partner. He abandoned the ULS in 2008, but he returned to assist Kavaziguruka register success in the year 2021 before the Constitutional Court, and he has this time not abandoned Kavaziguruka. I saw him in July last year completing the circle, walking the Lule walk, ensuring that the appeal from Kavaziguruka is argued by him just as he had argued below, or even much better. And he has done excellently. He has addressed almost 3 panels which have been reconstituted, as you know very well. So, Mr. Segona has done well to repair his reputation and his account. He's in good standing with the bar. As for David Impanga, I don't know. I don't know. I don't even know what he's doing at the General Court Martial. He caused this error. They are the same. They are the same. Maybe that's why he doesn't want to appear there. But he knows. David Impanga must know that he abandoned Mr. Dule when Dule needed him the most. And that's why we are here. The Supreme Court, those days when the Supreme Court was still a Supreme Court, could have resolved this issue on the 20th of January 2009, possibly prohibiting the military from continuing to try civilians. But we have had this problem with us for 16 years simply because young lawyers abandoned a senior lawyer to go and make money and hang around and prac around town doing commercial and corporate commercial nonsense. Now we are here. On the 19th of June 2013, in Supreme Court Civil Appeal number 4 of 2012, Namugerwa Hadija versus DPP and Attorney General, the top court avoided addressing this constitutional question. It had arisen during an ordinary appeal from the denial of a habeas corpus order in the High Court. Namugerwa Hadija had moved the High Court judge for the release of her relatives who were held in the General Court Martial. And her plea was simple through her lawyer, Ladislas Rakafuzi. They have no business holding these civilians. That detention is unlawful. And the procedure for making that argument, as you all know, is called a habeas corpus application. The High Court judge refused to grant the habeas corpus order, ruling that no, Section 119, subsection 1, clause G and H, permit the military court to hold civilians and handle them. So that detention is not unlawful. I reject the habeas corpus application. Senior Counsel Rakafuzi immediately applied to the Court of Appeal, and the Court of Appeal of those days had him immediately. So the appeal from the High Court was heard that year by the Court of Appeal. It agreed with the High Court judge, and he appealed immediately to the Supreme Court, and it had him immediately. So all these proceedings happened in 14 months between 2011 and 2012, and they gave him a judgment saying the issue was settled by a majority of 3-2 in Constitutional Petition 18 of 2005. The appeal from that issue was abandoned by Uganda Law Society. Our hands are tied. as a result of the Namgerwa decision, the military has continued to try civilians, leading to arbitrary arrests, detention, and torture. Most people here are so young to remember the reign of terror of Kaihura, where there is a high-profile murder, villages are circled up, profiled, good Muslim, bad Muslim, and detained in the general court-martial. Villages, children. Subsequent cases, what I call post-Kaihura cases. After the reign of terror of Kaihura, the Constitutional Court had a change of mind. The warnings that lawyers had made immediately after passing of the act, there was now a body of evidence. And here we must thank Makerere University, especially Dr. Naluwairo, who insisted on collecting the data at the General Court Martial, getting data from the General Court Martial. It has been his lifetime work to create a body of evidence that the General Court Martial is not a fit and proper place for civilians. He's now the principal of the School of Law. Previously, he had done this work through the auspices of the Human Rights and Peace Center. It wasn't the Law Society collecting this work, this data. Our members have tried, but our data is scattered in various habeas corpus applications like Namgerwa's. At least Ladislas Rwakafuzi took the matter to the highest court. Most people stop at the high court. After all, these are the poorest of the poor that we deal with. Other people can call. They have someone to call. Somebody is missing. So, subsequent cases after Namgerwa have progressively sought to resolve this pressing issue. Let me canvass them for you, Honorable Lord Mayor, and for Gwen and other Gen Zs to understand. After a 5-year delay, Constitutional Petition 45 of 2016, Honorable Michael Kabaziguruka versus Attorney General achieved a favorable ruling by a majority of 3-2 on the 1st of July 2021, declaring an end to civilian trials in military courts. Unequivocal. On the 15th of December 2022, that's a year after the Kabaziguruka decision, another decision which had been gathering dust in the Constitutional Court for 7 years was decided. Its name is Constitutional Petition number 44 of 2015, Captain Emon Biarugava and 169 others locked in the General Court Martial. These are civilians they have served sentences in excess of 7-10 years. They are saying still we are here, there's no other chance for us to get out of this system except a constitutional interpretation. That interpretation came after 7 years. Most of them had served sentences and left. Some are still there, although their sentences are completed. You know this. We are grateful again to the lawyers who did Biarugava, including Ladislas Rwakafuzi. This decision resulted in another favorable decision by a majority of 3-2, upholding the precedent set by the Kabaziguruka decision. Finally, the most recent decision, Semju Abdul Nur versus Attorney General. Constitutional Petition number 4 of 2018, which was resolved after a 5-year delay. Citizens secured another positive outcome, this time by a majority of 4-1, on the 3rd of February, 2023. For those of you who like trivia, judicial trivia, every justice who has been in the dissent has been given promotion to the Supreme Court. And one of them is on the panel. In the Kabaziruka decision. But there is some good fortune, some silver lining in all this. Most of them had the Kabaziruka decision, so they can't sit on the appeal. But you have seen the trajectory. There are those judges in the Supreme Court who may want something from the state, and they now know how to get it. Keep civilians in the military court and get a blank check from this state. Quid pro quo. Biampuna, as you say. No appeals have been filed against the Captain Biarugaba decision, and no appeal has been filed against the Semuju Abduno decision. And I think this is what disturbs you. Why aren't they implemented by a statutory authority like a general court martial? Why insist on the temporary stay of execution in Kavaziguruka, which was issued in 2021, and was specific for that time and context? Anyway, we are all here now because there is an appeal before the Supreme Court, which has been fully heard. It is known as Attorney General versus Michael Kavaziguruka. It has been heard a record 3 times. The Chief Justice likes to say that, of course, the first time the matter was heard, 2 justices died. My Lord Justice Ruby Pio Oweri and my Lady Justice Stella Arachamoko. The counter argument would be that why were they put on the panel? Yet it is now well known that they were too ill to do the work. Why were they put on the panel as mere space fillers? For an important question like, how does the judiciary do planning of human resources? Were they fit to be on the panel? They could have been present, but too ill to do the work as we now know. May their souls rest in peace. Why use their names as ping pong in a national context, national controversy? These were good judges. Some of the very best. Anyway, when they died, why weren't panels reconstituted immediately? Why did it take banging the table? You can go online and you see examples of banging the table. In the year 2022, I wrote an article, Why are Supreme Court judges earning money for free? We are spending nearly 300 million shillings per month for judges who are being sent home by the Supreme Court Chief Justice because he saw a rat in his office and some faulty wiring. But those have been, and I urge, but those have been the conditions of judicial service in that place for a long time. What is special? 7 months until we banged the table, then they told us, oh, we have found space. In November, from April to November, then they found space. Then they went into vacation after vacation, retreat after retreat. This case wasn't fixed. And then we banged another table. So in 2023, you will read the article. The Supreme Court has an Owini-Dolo problem. And again, we put the question of Kabaziguruka. And he began to accuse us of buying newspapers to write long articles, as if what we are saying is telling lies. No. We were showing, comparing him with previous Chief Justices who resolved constitutional questions timely, promptly, and justly. They made no excuses. They were also flying. They also had sick people. They didn't have youth in the Supreme Court, did they? They had elderly people. These were not excuses. In fact, what we argued in 2023 was clear. We said that the Odoki Supreme Court was always understaffed, and it ably utilized Article 42, Sub-Article 2, to invite acting justices, either from within the retired justice of the Supreme Court cohort, or the Court of Appeal, or the High Court, or even outside Uganda. Because it's allowed to get a judge for a session, a judge for a case. The procedure is in the law. Chief Justice Owini-Dolo has never invoked it. The case was again reheard because Justice Faith Monda retired without writing a ruling, and then they invited them in July last year. So there was a hearing. I saw Segona there because I had another case there myself in the same session. I know the judges. I saw them. These are their names. Chief Justice Owini-Dolo, Lady Justice Lydia Ntibate Mwechirukubinza, Lady Justice Percy Knight Tuhaise, Justice Mike Chibita, Lady Justice Elizabeth Musoke, Lady Justice Catherine Bamgemerire, and Lady Justice Monica Mugenyi. I saw them hear this case, and they reserved judgment in July of 2024. Now, according to Canon 6.2 of the Uganda Code of Judicial Conduct, a judicial officer, and that includes a justice of the Supreme Court, shall promptly dispose of court business. And where a judgment is reserved, it should be delivered within 60 days unless there's good reason for delay. ULS is gravely concerned by an unexplained delay of more than 210 days as we speak in delivering the judgment in Attorney General versus Michael Kabaziguruka, an appeal that has spent more than 4 years on the Supreme Court tables, shuffled from time to time, pending judgment. At all times it has been pending judgment, you must understand. Not hearing, but judgment. So even before the Supreme Court, the Owini-Dolo Supreme Court suffered vacancies due to illness or death, they were in breach of Canon 6.2. They had failed to deliver judgment within 60 days. They had taken a year. The experiences of civilians in military courts during this delay have left deep scars. Saram Kaga, you have scars, deep scars in the bailiff department. Imagine the countless individuals and families who have been caught in the dragnet of the UPDF Act. Imagine the depth of their scars for a moment. You saw for yourself the most recent spectacle of those who the military court took for wearing red berets, and stylish uniforms. In hundreds. sucked into the system. 4 years. No bail, no witness, no progress. And they are now speaking. Some have said, let's take the Balam route out of this place. The General Court Martial is a different ball game for civilians. The trial of civilians in the General Court Martial, with the greatest of respect, has caused long-term trauma and psychological distress. Honorable Lord Mayor spoke to why many lawyers have said no, have switched off. It's because trauma and psychological distress suffered by clients vicariously affects us who intervened. I am a good example. I can talk about this without crying. I have clients whose testicles have been cut off, nails have been pulled out. The things we have seen, you cannot unsee. We worry about hiring younger people like Gwen in our farms because we shall damage them through work hazard. So this work, at this point I should say, it has damaged our colleague Ladislas Rakafuzi. He opened extended hand to everybody, and he suffered massive stroke before even he was 60. He's now, we are taking care of him. Speaking of trauma and psychological distress, I cannot stress enough that the Karamoja region in particular has suffered greatly because its communities have been displaced and marginalized due to military actions against the alleged Karashunas. The military is conducting expeditions in Karamoja that you do not even have an idea about. Shoot to kill, mass arrests, screening. The most recent example was pictures on social media which shocked the Committee on Human Rights in Parliament because youth were starving in Gulu prison. They had been marched from Moroto, Kabong, Abim to Gulu prison, where you can't have visitation and everything, and they were fed on water and sprinkling of beans and posho whenever it is desirable to do so. Did you see those pictures? Well, you're lucky. They were swept out of the internet, so you can't see. Now, they are in their tens of thousands. And this is just in the last 2 years. 2,000 were released to go back home. So if 2,000 are known cases, how about the unknown cases? Contrary to Articles 28, Subarticle 1, which speaks of a speedy hearing as a fundamental right, no court has business, no court has a power, a right, or duty to conduct its business through delay. The standard is speedy. Contrary to Article 126, Subarticle 2, Clause B, principles of justice. Justice shall not be delayed. It's emphasized twice in the Constitution, in Articles 28 Sub-Article 1 and Article 126 Sub-Article 2b of the Constitution. Contrary to these clear, simple provisions concerning how the judiciary must be exemplary, above all constitutional organs, the top court's excruciating delay has emboldened the military to intimidate and harass advocates, journalists, and human rights defenders who dare to speak about these violations. This has created, as you said, my Lord Mayor, a chilling effect that silences critical voices and perpetuates a culture of fear and repression. When 23 lawyers resolve that the matter is beyond them now, they must hand it over to the radical new bar to lead from the front, because it can no longer be resolved through private client briefs. The agency of advocate-client autonomy has been exhausted. You have a duty to the public and to the society to report the limits of your capacity. You have done that. And we have received it in the name of our ancestors, and in the name of those living and the name of those to come. Mr. Elias Lukwago walked here on the 16th of January 2025 and declared that enough is enough. Enough. He had reached the limits of his capacity, and he handed this over to lawyers past, living, and prospective to take on. This is not an ordinary day, this is not an ordinary occasion. In contravention of Section 7 of the Judicature Act, which implores the Supreme Court to invoke as much power as lower courts have in conducting business before it, Rules 20 and 21 of the Supreme Court rules. Rule 20 says the Chief Justice solely is in charge of the business of the Supreme Court. He determines what gets done, when, and by whom, and where. Solely. He's the sole business manager in the Supreme Court. When he says the ruling shall be delivered not later than this date, every judge must obey. And we saw what he can do to those who don't obey him. We saw, and we know. It is Rule 20. Rule 21 says the Supreme Court can sit in vacations, weekends, when it determines that expedition is required. The power is in the rules. Rule 10 of the Constitutional Court Petitions and References Rules is even more clear. It says where constitutional matters are involved, and I think I heard you, Mr. Ramkaga, and your delegation speak to it. Was it Mr. Baguma? Rule 10. You remember the words of Rule 10? Yes. Come and educate the public. It's not for lawyers. Yes.
It says where there is urgency, they invoke Rule 10 and leave.
No urgency. Where there is constitutional
where there is no constitutional business, they leave all other businesses and attend to that constitutional matter in that regard.
Including sitting on public holidays.
Sitting on weekends, public holidays, even at night, as they did in Mbale.
Yes. And who took us to Mbale? Chief Justice Owinidoro, when he was Deputy Chief Justice. So contrary to all these clear rules, we submit, colleagues, that the Chief Justice has sincerely failed to ensure that his colleagues on the Kabaziguruka decision, the Kabaziguruka quorum, comply with Canon 6.2 of the Uganda Code of Judicial Conduct. And this has undermined the principles of fairness, of justice. Justice must not be delayed. Justice must be speedy. Finality of litigation. We are talking of 25 years, 42 justices of the Supreme Court and Court of Appeal, reaching endless and chaotic decisions on just one provision, the PDF Act. The ordinary citizen is confused. Is Uganda incapable of pronouncing with clarity the laws Parliament has written, the Constitution it made for itself? Why do we pay these people? Why do we continue to pay them if they cannot serve us the sole product and service we want from them, justice? Now, we are aware that the justices of the Court of Appeal and the Supreme Court are in retreat in Mbarara, where they have been since Monday the 13th, and they will be there until tomorrow the 17th, to discuss appellate court business, I would presume, and welfare, of course. But I hope one of them has raised the issue that they are in breach. They are in breach of a cardinal duty to resolve the Kabaziguruka appeal promptly, now that the public honestly has reached breaking point. The public's patience has reached breaking point. It is my humble submission, colleagues, that we have reached a point where open, relentless, and severe criticism of Chief Justice Owini Doro and his Supreme Court can no longer be avoided. Their curious and culpable delay on the Kabaziguruka appeal alone has eroded and continues to erode trust in the judiciary, perpetuating a culture of impunity and disregard for the rule of law. Due to their delay in delivering this judgment, our Supreme Court luminaries are now perceived as enablers of military repression of political opponents, stifling dissent and perpetuating a culture of fear. Why don't they listen to what the public thinks of them now? Isn't that a breach of Article 126, Sub-Article 1, that they sit in those offices in our name and they perform their duties based on our trust? So our perceptions of their fidelity matters. And today, I hope we have used the clear words to deliver the message while they are in retreat. For the sake of vulnerable communities like those in Karamoja, who are at the clear and present risk of continued military incursions into their homes, and farmyards. For the sake of the Karamajongs, because that's what they call them in Chitalia. Mariam, come here. Is that what they call them? Is that what they call general court martial suspects in Chitalia? What do they call them? They call them Karamajongs. It's colloquial now. I was there. I went to see Aaron. And I heard it. They call them Karamajongs. It's normal. Those Karamajongs, a general had visited to conduct pardon proceedings. It's now normal. For them, lawyers don't see them. There's no need. We had a retreat last week with our teams from that area. Kabong, Abim, yes, help me. Kabong, Moyo, and Arua. Yeah, but the Kabong team was able to tell us what happens in that area. And they told us, we use a different method with the general court martial and the Karamoja situation. We achieve more in this manner. So, my Lord Justice of Appeal, Justice of the Supreme Court, this is the feedback. Ugandans have found a way of finding justice when confronted with the dilemma of martial law, and it doesn't include waiting for you. Olivia Rutaya did not wait for you. She waited, and 4 years was enough. She took matters into her own hands. She invoked her own agency. And many others. So we urge the Supreme Court, for the sake of Karamoja at least, which has the most number of victims, they are in tens of thousands presently. If we count the cost of 2,000, because these things, they call it what? These expeditions began in 2002. Dr. Honoria wrote a report on it, I remember. Disarmament, they call them. Disarmament campaigns. They began in Karamoja. We have never done, okay, now maybe I was educated by the Legal Aid Project, that they deal with the picking up the pieces of a disarmament campaign. So, for the sake of Karamoja at least, please, the Supreme Court, you must act with urgency and some humanity to deliver this long overdue judgment in Attorney General versus Michael Kavaziguruka. You may hate Besije and you may hate Lukwago. That's okay. You may hate Martha Karua. That's okay. But those kids in Karamoja are just children. They're just children. They're just children. They have never been to Kampala except to see the court martial. Except to see the court martial. And the person who should be protecting them, their own, sits back and watches. I received numerous calls from people I didn't know when I was on sick leave, telling me, don't they apologize. We are defending you. We are telling her, my name is so-and-so. I am her nephew. I am her niece. What did she do? Don't dare apologize. If you dare apologize, you are a hero in Karamoja, Isaac. They were telling me, absolute strangers. We have a crisis in Karamoja, and it is wrapped up in Kavaziguruka. I hope I have educated you better about the data the Law Society has, which has received your petition. Your petition comes from even a position of privilege. It can be written. But for the Karamajongs, we have to pick intelligence and data from conducting retreats with our staff, and we ask them, what weren't you able to do? And they say we couldn't get Karamajongs, hundreds and thousands, from the dragnet of Masholo. We don't have the resource. We don't even know where to begin. It is therefore crucial that our meeting with the Chief Justice, when it happens, and I hope he doesn't cancel it now because we have spoken. But we hope that when it happens, it should result in one thing and one thing only, a judgment date in the Kavaziguruka appeal. He was giving an interview in the Monitor recently, and he said the characteristic of justice is to act without fear. But why does he fear? Isn't this fear? One wonders, what do the Supreme Court judges fear? Why are they pussyfooting, dilly-dallying? And whispering over the Kavaziguruka decision? It is crucial that if or when our meeting with the Chief Justice happens, it should result in a judgment date to arrest public anger and curb long-term harm to our judiciary. We can't take 25 years and employ 42 justices of the Court of Appeal and the Supreme Court to arrive at an unclear result on the interpretation of Section 119, subsection 1G and H, vis-a-vis its conformity with Articles 28 sub-article 1, 126 sub-article 1, and 210 of the Constitution. That's a question students use 2 hours, 40 minutes at LLB level to resolve. Why do judges think they need countless hours? This question can be resolved, and students are marked for proficiency in constitutional law, LLB 1 and LLB 2, within 45 minutes. But the judges of Uganda, 45 of them need 25 years. And a senior lawyer like Mr. Lukwago tells you that's not enough. You need banging of tables to get them to do their work. What do these retreats benefit them? And why do they lock us out from those retreats? This is why we scheduled our first R&B at this point, so that we force ourselves into their retreat. They hear our voices. You may be in Mbarara, but we are addressing you now. Discuss this issue today or tomorrow, or return on Monday to face us. We are ready for you as well, Doro. We are ready. We call upon the Supreme Court, and they are good judges. We call upon the Supreme Court who do not have the pulpit the Chief Justice has. We call upon the remaining 6 to overwhelm Justice Doro, Chief Justice Doro. Overwhelm him and say that for you already. Step out of the prison you're in. If the Supreme Court has become a prison, step out of it. We are here to protect you. There's an international community of justices and jurists to protect you. Every justice we have mentioned, you have a duty to tell us that for you, you're ready. We don't care which way you rule. We just want your judgment. Yesterday. Please, we call upon you to find time as a quorum or as a Supreme Court. Find time for another retreat between January 20th and the 31st of January this year to put a stop to this culpable delay and fix a historical wrong that has undermined the legitimacy of our judiciary and the entire legal system. Why should the General Court Martial reconvene on the 3rd of February this year? when the judges will be beginning yet another retreat. Without having received guidance of the Supreme Court, what will they be retreating about? Who will they be retreating as? Because if you don't do justice, why do you accept the title? Colleagues, that's the end of my speech.
All right, let's clap for President once again. We've had 3 different sessions. We've addressed 3 different matters. And it would be unfair to leave without giving an opportunity for some reactions. So if anyone has a reaction, I'll invite a few from the court bailiffs issue, from the case census and the court martial. We'll just use a few minutes because we've used a lot of time. So we'll have 5 minutes for each session. So if you have any reaction from within and I think online, do you have some online? We can address those. Yes, sir. Please come.
Again, good afternoon to you all.
Please. Maybe some housekeeping. All right. Colleagues, we have detained the Lord Mayor of the city in one place for a very long time. He was performing a delegated function on behalf of a client and an entire legal team. We thank you for showing us the humility with which legal services must be performed. But we must now release him so he can attend to city authority responsibilities. Thank you. I will guide him off.
All right, thank you. Let's clap for the Lord Mayor. Thank you for coming. All right, as the Lord Mayor takes leave, let's proceed with the reactions. Please introduce yourself and you can introduce yourself.
Yeah, good afternoon to you all. Again, I'm Tunao Asaf. I also want to add my voice on unfairness. For example, when they are making these rules, there are some issues which were not addressed. For example, the senior bailiffs, for example, somebody who has been in a bailiff industry more than 20 years, and there are some bailiffs who have mentored those who have diplomas, and again, there are bailiffs who have degrees of different disciplines, other diplomas, different disciplines. And again, we are not considered with stakeholders, maybe to bring in our views. And to when we are forced to go to LDC to study those certificates, which we have, which I think was good enough for bailiff industry, they just brought this diploma abrupt without giving our notes. Otherwise, people are willing to go to study, but they need time. And time, of course, should be more than 5 years. Like somebody who is in 30 years experience and just all of a sudden said, please stop. To me, it is an unfairness. I use the example, somebody like Ason Zerwa Muganga, he has been practicing more than 30 years. Now he said, please stop. Really, it's unfair. And again, it is my voice and prayer, if there is this engagement to judiciary or to the people of who are the apex of the office, consider speak like some two senior bailiffs. They can some are chip in their advices on the fairness. And when I was at LDC, there is what I studied, one of the fundamental principles, doctrine of law. For example, if you don't hear somebody, you just make an independent judgment. To me, it is unfair. And I will not, before I sit, I am going to use this word in the Bible. In the book of Psalms, Lord said, I am the supreme judge. I will judge the world, rule the evil to its end. If I can be captured on that, I think that is very can guide. And I believe those who are in judiciary, they make an oath. I hear using the Bible. If it was possible, people can follow the Bible, it will make a lot of sense to them, to the society, to the public. At the end of the day, we should know, even if you are in that office, we should know that there is that supreme judge who is judging everybody. Either you are in office or you are not in the office. So I really chip in my advice. Maybe one word. Like me, I've been in practice since '99. That experience, once you just lose it, me, I don't mind. I can go home and rest. I can join my garden and do other things. But again, the youth who are behind me, they are going to lose my experience and my code of conduct. Once when I was at LDC, one of my lecturers called Nelson Nerema told me that a professional person is a person who has the code of conduct and skills. To my side and thinking, if you have a PhD in law and you are a thief, you are equal to that somebody who has not gone to school, who has not, because we have people, yes, this is a measure, but again, there are some key points which are not considered. Me, I believe in code of conduct and skills. Which skills I believe I have since '99, it is not this year which I have not renewed, but since '99, I have been up to now. And we have mentored many advocates. Our sons are advocates right now. Like I will not share this. I have my biological son, who is at Makerere University, doing group. So, some of us, we like education. That's why we can support the children. And recently, one of our daughters, my brother's daughter, they are young grade 1 magistrates. Those ones, we are the ones who assisted them. And so now I believe, maybe one point to face it. When I am your father, and we have educated you, does it mean that I should die? Or I should go? No, there are some other issues you should know. Like our President of the Society, really when you talk to there are some, I have seen my members crying. That is really, but we know, as I said, God is a supreme judge who will judge the world and rule the evil to its end. At the end of the day, some of us, we are getting old, we found Uganda, and we are going. Even if you are what? Age is not, it's like, you cannot avoid it. Like, for example, a man like Ruamkaga is 60 years almost. He's going to 2 years, 3 years, now he goes to study. Yes, it's good, education is good, by the way. Like here now we have come, we are studying. This interaction is very good. Like me, President of the Society, it is my first time to see you here physically. But we are really, we are watching you, we are seeing what you are writing, and really we are very happy. Around some good years back, I was on the panel chess championship. Sometime back, I know chess, I'm a chess player. And I am a mathematician. Sometime back, I was a teacher for mathematics. Primary at the secondary level. Like now, when you say go to class and do mathematics, really, you will do wonders. Me, I'm a mathematician. But by somebody wants to know things to study, And me, I urge, that's why even the government now wants everybody at least to have the knowledge of law. That's why this administrative law this was introduced. Says that everybody is aware. Like before when you started this briefing, at least many people will take advantage. And this one, before I move, to me, we have executive, Uganda UCBA. Some of us, we are not on executive. If you can pick one person or two, because people can be there, others are shy, others they have their, for me, I'm not a politician. I just talk independent mind, and whenever, what I have seen, because I'm 57 years now, even if you go to court to me now, what do I want here? Because it appears we are mispressed. If there was some of us would just leave this country and do, but again, we have our motherland, we will have people, and that's so. Otherwise, because of time, I would have started, because when Mayor was going, I would have started protocol observed. You will just excuse me not to follow the protocol, but that is my prayer that in case for future interactions with judiciary, even if we were there to offices, you can call us and we interact. We have vision. Saying this and that.
All right. Okay, thank you very much, Asaf. That was Asaf's reaction, not a question really, but he's adding a voice to what has been discussed regarding the issue of the bailiffs petition and their concerns. Do we have any other reaction, question? Yes, sir. You're welcome. Speak through.
All protocol observed. My name is Asifiwe Dan. I'm also a bailiff. I've been in the bailiffing business now. This is my 8th year. With profound appreciation, I'd like to appreciate the President, Uganda Law Society, for ably communicating to us. I'll start with the court-martial issue. I should say, personally, I'm a victim, Mr. President. In Kasese, one of my uncles, I think it was after the elections, it should have been either 2021 or 2016 or thereabout, my uncle secured for me a place at Uganda Pentecostal University to do law, was charged in the court-martial. I want to tell you, if you've never had a relative or a family member in that place, you don't know what goes around there. What the president said, I was shedding tears when he reached that point because I remember vividly what happened. My uncle, a respected member of society, a teacher, being tossed up and about and being treated like a riffraff just because you are being accused of the crimes that you did not even commit. So really, I would like to add my voice to what the president said, that indeed we have a very big cancer if the Kabaziguruka case is not handled effective yesterday, because we have other people who have not had the opportunity of their families being able to speak out. Because personally, yes, my elder brother is a lawyer. We managed and tried our best. I just finished my LLB and I had nowhere to go, and this case was coming up. But we tried to fight hard. But how many families have that opportunity? That you have someone who can air a voice on your behalf? There are very few. But then we have a system which is supposed to fight for all of us, and the one who is at the helm of the system is quiet. Not because they are not ready, but because, as the president put it, they're just waiting to play their politics, which is really not a nice thing. So I really urge that let that case be handled, and also add my voice that indeed, on what the president has said, should be handled sooner than yesterday, because families suffer. Personally, I still have that trauma. Even up to today, when you mention the general court martial, I look at it as a bench of monsters. I will speak it without fear or favor. Because what my uncle went through up to today, it still haunts us as his children. And it's really disheartening. Then for the bailiffs, in our language, we have a saying, and I'll say it as it is, that ikakua enamwahera, loosely translated that you die fighting. Yes, we have the rules upon us and they are unfair. And we have put our voice before the President, Uganda Law Society. But I still implore my colleagues that in as much as we are pushing this, let us also try to get what they want, because you don't know what will happen tomorrow. It may be a diploma today, then tomorrow they'll tell you they want an LLB. What are you going to do? And then also, on the issue of time, yes, as we push for this and have time, we also request that, Mr. President, in a special way, when you're pushing forward for the issue of bailiffs, we request that on top of the executive of the UCBA, at least we should have an additional 5 senior bailiffs to join you on that team when you're going to address our issue, so that we can ably bring our minds together and ensure that this issue is ably handled. Because it is not only looking at the education perspective, but we also have the remuneration perspective. Our remuneration has been greatly affected by the rules. So we should not only look at the time factor of education, but also the remuneration. Actually, all the rules, we need a complete overhaul and have an involvement of all stakeholders in UCBA, not only the executive and the rules committee, but we should also have representatives from the society who subscribe, especially our seniors, who will also add a voice on that issue. Thank you very much.
Thank you very much. Let's clap for him. I'll allow 2 more because it's 2 p.m. and we'll need to close. Or 1. Do you have any other? They are all coming from this side. What's happening this side? All right, we'll take then that as the last one. I've also not seen a lady. We need to balance gender here. Yeah, she has gone. All right.
Yeah, thank you once more, Your Excellency. I really want to thank you so much for your speech about violation of human rights and constitutionalism. As a student of law, as you are speaking, actually, it's as if you are lecturing me, and I must thank you so much for your remarks. Once more, as a representative of Bailiffs Fraternity, I really want to emphasize that the law that they are using to victimize us were done without necessarily consulting us. The little law I've learned from the UPU where I go to study my LLB, I've learned that before you put a law in effect, you must consult the people who are going to be affected by it, so that you pick information from them, how it is going to be administered, how it is going to affect them. So the point I'm making once more is that I don't know why judiciary chose not to really see it as an important aspect of law to come through us and really, throwing the law to us without necessarily consulting us. So I want to really request you to take it as a point, and as my colleague was requesting, we really need to be together in these meetings. When we come here, we run a lot. If you invite us or if you keep notifying us about this, we really benefit from, from this meeting. So I want to thank you once more for inviting us, giving us time, and also accepting to advocate for our issues. I thank you so much.
All right, thank you very much. I'll take that as the final reaction. This was the first of our weekly press and public engagement with the Radical New Bar. Today we had 3 issues, the bailiffs petition, which you had, and our response to that, a court case census, and the general court martial issues. Now, it doesn't mean it stops here. What we are trying to do as the Radical New Bar is to fulfill our obligation, our statutory role, as far as the Advocates Act is concerned. we have a duty, we have a role we play to the public, the government, and to the members. And this is part of what we are doing. The issues we'll be discussing during these sessions, this series, matters touching rule of law, matters touching access to justice, and for the members online, we'll also discuss some matters touching the membership or members' matters, because it is also our duty as the Radical New Bar Council. So on behalf of the President and Council generally, I would like to thank everyone who has participated, those online, those ones who have been here physically. And please take this as an opportunity to have engagements and discussions with the Radical New Bar where we feel, where we don't want to just speak, we want to act. We believe in taking action, not just coming up with proposals, and we sit with them. And we believe we can do this openly for purposes of accountability and not doing things in the back. So instead of sitting back and wait and ask what is the Radical New Bar doing, this is one way of doing things. This is one way of serving and doing our role and our duty. So thank you very much. I hereby close this series of weekly press and public engagement with the Radical New Bar for today. Thank you.